Next, the issue concerning the calculation of front royalties. The IP High Court calculated it in this way, as shown in this slide. But for the sake of time, I'm not going into details about the calculation method. So I skip the following 4 slides. But I'd like to point out that one of the main characteristics of the calculation of front royalty by the IP High Court was that, as shown in this slide, in the third item, the IP High Court divided the figure by the number of SEPs in the standard without taking into account their different value. I mean, the different values of SEPs, patents, individual patents in the standard. So in other words, the court adopted numerical proportionality. Theoretically, such a treatment is doubtful, but it was probably unavoidable because of the limits of the evidence in this case, in this particular case. Finally, the issue of competition law. Mr. Ikeda already talked about the competition law aspect of the IP High Court decision in Apple versus Samsung. The IP High Court said, as shown in this slide in the 3 lines from the bottom, the claim for damages not exceeding the front royalty constitutes a breach of the Anti-Monopoly Act. The entire evidence is not sufficient to prove that the claim for damages exceeding the front royalty constitutes a breach of the Anti-Monopoly Act. I think this statement is off the point, as it ignores Samsung's conduct of seeking injunctions. So, as shown in the previous slide, the court touched on only the claim for damages not exceeding the front royalty. I suppose in this particular case, Apple versus Samsung, neither the IP High Court nor Apple took seriously the issue of anti-competitiveness of the conduct by Samsung because there were already other factors sufficient to find abuse of right. So in this particular case, the issue related to competition law was not taken seriously. That is what I'd like to say. However, in the second point in this slide, as a matter of competition policy, clarification of the treatment of enforcement of SEPs under the Anti-Monopoly Act is warranted, is necessary, because the possibility of the imposition of severe sanctions, such as surcharges and even criminal sanctions, might affect the patentee's behavior. So we need more clarification. And the next slide explains or shows what types of anti-competitive conducts may be found as to the enforcement of front-and-covered SEPs under the Japanese Anti-Monopoly Act. And in the context of competition law and SEPs, I'd like to introduce another case in Japan which involved involved the issue of front-encumbered SEPs. It is Imation versus One Blue. The defendant was a patent management company which was entrusted with front-encumbered SEPs related to standards for Blu-ray discs by the patentees. So the defendant was, in a sense, a patent assertion entity, PAE. The plaintiff was selling Blu-ray discs adapting the standards. The defendant sent warning letters to the plaintiff's major clients mentioning the defendant's right to injunction against the plaintiff's infringement of the SEPs. The plaintiff sued against the defendant, alleging that the latter's conduct constituted firstly, acts of unfair competition under the Unfair Competition Prevention Act. And also, as secondly, as unfair trade practices under the Anti-Monopoly Act. The Tokyo District Court in 2015 affirmed that the defendant's conduct were acts of unfair competition because the plaintiff was willing to agree on a front-based license contract, and thus the defendant could not enjoin the plaintiff's sale of Blu-ray discs. However, the Tokyo District Court didn't touch on the claim based on the Anti-Monopoly Act because already by affirming the claim based on the Unfair Competition Prevention Act, the claim was fulfilled. On this decision, commentators in Japan, including some competition law scholars, say that the same conclusion could be reached as to the presence of unfair trade practices under the Anti-Monopoly Act. And lastly, the JFTC issued the guidelines, issued or revised the guidelines for the use of IP under the Anti-Monopoly Act. Mr. Ikeda already explained about the new guidelines. So I would like to limit my comments to just two. Firstly, the scope of the newly added guidelines is very narrow. Namely, the revised parts relate only to front-encumbered SEPs. In other words, the new guidelines are not discussing the enforcement of patents in standards in a broader sense. And secondly, the guidelines do not present any clear criteria to judge whether the standard implementer is a willing licensee or not. So there is no clear criteria as to the judgment concerning the willing licensee. I skipped these slides. So as a conclusion of my presentation, I would like to point out that there are at least two important legal issues that are unresolved or not clarified yet in Japan. One is the legal obligation of transferees of front-encumbered SEPs. As Mr. Ikeda explained, the JFTC's guidelines simply say that the transferees would, the conducts by the transferees would be treated just in the same way as parties who actually gave front declarations, but I don't think that the legal grounds are very clear on that point. And the other remaining issue is, as I mentioned several times, the criteria for judging the willingness of standard implementers. On this point, the development in Europe would be very suggestive, very instructive for us, but we still need to find out an appropriate way for Japan, I think. So I'm planning to continue my research on these issues myself. Okay, this concludes my presentation, and thank you for your attention.